and then see if settlement is there, we'll close it. Petitioner shall serve on the complainant.
That is the page number 14, my lordship.
No, sir. ನೀವು ಇದೀರಾ ರೆಸ್ಪಾಂಡೆಂಟ್?
No,
ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್
ನೆಕ್ಸ್ಟ್ ಮಾಡಿ ನೀವು
Fresh
ಫಾಸ್ಟ್
matter.
ಆಗ್ಬಿಟ್ಟಿದ್ದೀರಾ. ಆಯ್ತು ಸರಿ.
the fresh matter, my lordship.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕರೆಕ್ಟ್. ಎಮರ್ಜೆಂಟ್ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್. ನೆಕ್ಸ್ಟ್.
Obliged.
petition.
I am per respondent number 2.
Keep it to emergent notice ಅಷ್ಟೇ.
There is an interim matter subsisting in this matter.
Why did it get posted then?
I am per respondent number 2.
Vacating stay ಹಾಕಿದ್ದೀರಾ ಸರ್?
They have not filed, they are yet to file their response, my lords.
File your
Okay.
objections.
Investigation ಗೆ ಹೇಳಿದ್ರು ಸ್ವಾಮಿ ಗವರ್ಮೆಂಟ್ ಇವ್ರಿಗೆ.
ಇರ್ಲಿ ತೊಂದರೆ ಇಲ್ಲ. ಎಸ್ ನೀವು objections ಹಾಕಿ. List the matter on 24th September. Objections if any by the respondent by then. Interim order subsisting will continue till the next date of hearing.
Great.
Shanti Bhushan is directed to accept notice for the second respondent. Petitioner to serve set of papers upon the aforesaid counsel.
Yes.
List the matter on Monday ಹಾಕೋಣ. Tuesday 16th. 16th, 17th in the fresh matters. ಇವತ್ತೇ serve ಮಾಡಿ. Yes. By then he will get all instructions. It will be easier.
38. 7 of EDC cleared. Cognizant itself.
Post the matter. Urgency ಏನಿದೆ ಮೇಡಮ್?
Urgency passport application ಇದೆ on job, he is losing.
ಇದನ್ನ ಅದು same order. You implead Shanti Bhushan will grant. Sorry, impleed RPO. Yes.
Writ is pending, that writ.
Which writ?
Where ಇದೆ ಅದಕ್ಕೆ?
Number ಕೊಡಿ. Writ number ಕೊಡಿ ಮೇಡಮ್.
I'll furnish my lord.
ಕೊಡಿ, will tag this petition along with so and so. Yes, next.
If this is disposed of, that clears my lord.
ಅದು ಟ್ಯಾಗ್ ಮಾಡ್ಬೇಡ ಬಿಡಿ. ಒಂದೇ ಸರಿ ಎರಡು ಮಾಡಿದ್ರೆ.
Yes.
ನೆಕ್ಸ್ಟ್.
130. ಏನು date ಯಾವ್ದು?
139.
ಯಾವ್ದು?
This case I am.
ಅದು ಫಸ್ಟ್ ಟ್ಯಾಗ್ ಮಾಡಿ. It will come post the matter on 13th. Yes, next.
In this case I am for the petitioner.
Post immediately after service of notice upon the first respondent.
This is not necessary because the petitioner is the complaint before the trial court. He filed a PCR. PCR was in the PCR source statement recorded.
ನೀವೇ ಹಾಕಿದ್ದು ಅಯ್ಯೇ.
The recording of the sworn statement, my lord, 55 documents are marked. After marking of the documents,
List day after tomorrow in the fresh matters list. Learned counsel submits that he's filed an application not to press. ಅಯ್ಯೇ ಒಂದೇನು? Stayನಾ?
stay ಕೇಳಿದ್ವಿ, not press.
Not to press the application seeking stay. The submission is placed on record. IA 1 of 24 is disposed as not pressed. Next.
140.
My lord, I am permitted to represent the petitioner.
CC of 2019, sir.
Yes, my lord, now the charges are not framed. The only allegation is that while I was the manager, I had sanctioned the loan for a sum of rupees 49 lakhs. It is essentially a suit which ought to have been filed for recovery, my lord. Now the amount that is claimed for 49 lakhs 67,000 by the company.
Yes, 1 HCGP 2 emergent notice. Yes.
My lord, may I request, my lord, so far as petitioner number 4 is concerned, the order of taking cognizance is
You are
very
the
bad.
only petitioner here is accused number 4. Yes.
Therefore, my lord, if the
No, sir.
proceedings, if
Yes.
the only difficulty that we are facing is that, my lord, if charges are framed,
No.
very
yes,
purpose of
sir.
petition.
No problem. You have filed a petition, we've issued notice. Even charges are framed, we will take care of it.
My lord, may I request for a shorter date, my lord, since emergent
In the
notice is
meantime,
ordered.
yes. Next.
My lord, may I request for a shorter date? my
What
lord?
is the civil suit number?
1802 of 2014.
All right, anyway, in the meantime, next.
Public.
142.
Represent petitioners, my lord. Arising out of the Copyright Act in respect of the same matters, CC number 1005/24. On 2/2/24, my lord has granted the stay order, stay of further proceedings.
2/2/24, not my order. Could you know?
My lord,
Where is that page?
it's page number 22, my lords. I have stated so, but I could not keep the order on my hand. Page number 22, I have mentioned it.
If it's 2/2/24, it's not my order.
No, my page,
Yes.
3 criminal petitions have been entertained by this court with reference to
Page,
page
numbers.
number 22, grounds for interim relief. Criminal petition 5620/23.
Tag this petition, heard the learned senior counsel MB Nargund appearing for the petitioner. Tag this petition along with ಇಲ್ಲಿ ಇದು ಹಾಕಿದ್ದೇನೆ.
Criminal petition 1005/24.
ಮೂರಿದೆ. ಅದ್ರಲ್ಲಿ ಏನ್ ಎಂಟ್ರಿ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡಿ. ಅದ್ರಲ್ಲಿ ಏನ್ ಆರ್ಡರ್ ಆಗಿದೆ ಅದು ಮಾಡಿ. Yes.
43.
List them all on 30th. Yes. The meantime, next.
144.
13th, sorry, 20th.
suspension move ಮಾಡಿದ್ರು ಅದಕ್ಕೋಸ್ಕರ. I just not take more than half a month.
ಆಯ್ತು ಮಾಡ್ಲಿ ಬಿಡಿ. ನಾನು ಕೇಳಿದೆ ನಿಮ್ಗೆ ಸರ್ಕ್ಯುಲರ್ ಕೊಡಿ, DA ಕೇಸಲ್ಲಿ ಸಸ್ಪೆಂಡ್ ಮಾಡಬಾರ್ದು ಅಂತ. ವೆರ್ ಇಸ್ ದಟ್ ಸರ್ಕ್ಯುಲರ್? ಗವರ್ಮೆಂಟ್ ಸರ್ಕ್ಯುಲರ್ ವೆರ್ ಇಸ್? ಅದು ಇಂಟರ್ಪ್ರಿಟ್ ಮಾಡಿ ವಿಲ್ ಪಾಸ್ ಮಾಡ್ ಅಂದ್ರೆ ಯಾರು ಕೊಡ್ತಾನೆ ಇಲ್ಲ ಸರ್. ವೆಂಕಟೇಶ್ ದಳ್ವಾಯ್ ಅವ್ರಿಗೂ ಹೇಳಿದೆ. ಗೆಟ್ ಇಟ್ ಟುಮಾರೋ.
Just only one submission.
ಆಲ್ ರೈಟ್, ಯುವರ್ ಸಬ್ಮಿಷನ್ಸ್ ಟುಮಾರೋ.
Yes.
ಎಸ್. ನೆಕ್ಸ್ಟ್
145.
7A 13th.
Please,
This
permit it, notif, no.
Learned Counsel B. Latif is directed to accept notice for the respondent. Registry to print the name of Counsel B. Latif as appearing for the respondent. Petitioner to serve set of papers upon so and so, list on 13th. Other matters are there on 13th.
Please, in the meanwhile.
Heard the Learned Senior Counsel. In the meanwhile, 13th. Yes, sir. Yes.
Please.
In the meantime, serve on the counsel, the
It's covered by your lordship's order
Ah,
from
I
the
know.
Kalburgi bench.
Kodi. But you have to serve.
Please.
17A, yes. Learned HCGP is directed to accept notice for the respondent. Second respondent yaru? Same.
The
Learned
competent
HCGP is
authority.
directed to accept notice for the respondents. List the matter on 26th till such time further proceedings where the petitioner shall remain stayed in the light of the submission of the counsel for the petitioner that the issue in the list stands answered by the judgment rendered by this court and writ petition so and so. Next.
147, my lord.
A1,
A1 may
no?
urge your lordship that he
Charge
requires
Charge
protection.
sheet file ಮಾಡಿದ್ದಾರೆ.
170 of 24, charge sheet number.
Challenge that.
Please.
Yes, so and so. A1 even then have to make out a case. Others, no problem. Yes.
Please.
48.
For the petitioners, my lord. There are three complaints and fourth complaint is before the learned magistrate. And first complaint NCR is dated 19/1/22 and second complaint NCR is on 24/11/23.
One emergent notice, two HCGP. The emergent notice returnable by 27th in the meantime. Yes, next. Date, sir.
49.
Stayed.
149 appearing for the petition lordship. Still is in summon stage lordship.
FB post, yes, in the meantime. Yes, next.
Oblige.
150.
323 and
Correct. 2016 crime.
yes, my lord. Kindly see the
TC
annexure.
20, petition 24.
Yes, sir.
ಎಲ್ಲ 4 ವರ್ಷ ಗ್ಯಾಪ್ ಅಲ್ಲಿ.
Well, please see the annexure B, my lord.
What is C, sir?
Annexure B, my lord.
No,
Annexure B ನಲ್ಲಿ ಅಲ್ಲಿ ಕೂಡ ಏನು ಅಲಿಗೇಷನ್ ಹೇಳಿದ್ರು ಅದು ಕೂಡ
ಪರವಾಗಿಲ್ಲ, 8 ವರ್ಷ ಆಗಿದೆ.
ಅದ್ರ ನೇತ್ರಾವತಿನ ಕೈ ಬಿಡಬೇಕು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ ಅದ್ರ ಕೂಡ annexure B.
Yes, what's the stage, madam?
Very
ಇದುವರೆಗೂ ಕೂಡ ಮೇಲೆ
We'll call this matter in 2028. 4 years gap ಆಗುತ್ತೆ ಎಲ್ಲದು ಕರೆಕ್ಟ್ ಆಗವ.
ಪ್ಲೀಸ್ ಸಿ ದಿ annexure B.
Yes. 1 HCGP, 2 emergent notice returnable by 27th.
Stay, my lord.
No, sir.
kindly please see the
No,
annexure
sir.
B, my lord. ಅದ್ರಲ್ಲಿ ನೇತ್ರಾವತಿನ ಕೈ ಅವ್ರು ಏನು ಮಾಡಿಲ್ಲ ಅಂತ ಆದ್ರೂ ಕೂಡ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಮೇಲೆ
ಆಯ್ತು, ಈಗ ಏನಾಗಿದೆ ಅಲ್ಲಿ? ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆಗಿದೆಯಾ?
ಇನ್ನು ಏನು ಮಾಡಿ
ಏನಾಗಿಲ್ಲ ಅಲ್ವಾ? ಏನು ಆಗಲ್ಲ ಬಿಡಿ. 27th, next.
ಪ್ಲೀಸ್ ಸಿ ದಿ
27th, yes, sir.
151. B report is filed, ma'am.
ತಡಿ, ಒಂದ್ ನಿಮಿಷ. ಅರವಿಂದ್ ನೇಗ್ಲೂರ್ ಅವರೇ, ಒಂದ್ ನಿಮಿಷ ತಡಿ. ಏನ್ ನೋಡ್ಬೇಕು?
Case
ಹೇಳಿ.
counter case.
ಒಂದ್ ನಿಮಿಷ. ಏನ್ ನೋಡ್ಬೇಕು ಹೇಳಿ?
ಪ್ಲೀಸ್ annexure B, my lord.
ಪೇಜ್
page 26, man.
ಹೇಳಿ. ಫಿರ್ಯಾದಿ ಹೇಳಿಕೆ.
Yes, my lord.
ಹಾ
ಇದು undated statement, my lord.
ಸರಿ, ಇದ್ರಲ್ಲಿ ಏನ್ ಹೇಳ್ಬೇಕು?
ಆಮೇಲೆ ಪ್ಲೀಸ್ ಸಿ ದಿ ಸೆಕೆಂಡ್ ಪ್ರಕರಣದಲ್ಲಿ ನನ್ನ ಮರು ಹೇಳಿಕೆ ಏನಂದ್ರೆ 17/11/16 ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಹೇಳಿಕೆ ನೀಡುವಾಗ ಘಟನೆಯ ಸಮಯವನ್ನು ರಾತ್ರಿ 10 ಗಂಟೆ ಎಂದು ಹೇಳಿಕೆಯನ್ನು ನೀಡಿರುತ್ತೇನೆ. ಆದರೆ ನಾನು ಆಸ್ಪತ್ರೆಯಲ್ಲಿ ಚಿಕಿತ್ಸೆ ಪಡೆಯುತ್ತಿದ್ದರಿಂದ ಗಾಬರಿಯಲ್ಲಿ ಘಟನೆ ನಡೆದ ಸಮಯ 11:30 ಆಗಿರುತ್ತದೆ. ದೇವರಾಜು ರವರು ಸೌದೆ ಪಾಳಿನಿಂದ ನನ್ನ ಎಡ ಕೈ ಮುಂಗೈಗೆ ಹೊಡೆದು ರಕ್ತ
11:30 ಇನ್ಸಿಡೆಂಟ್ ಆದ್ರೆ 10 ಗಂಟೆಗೆ ಟ್ರೀಟ್ಮೆಂಟ್ ಶುರು ಮಾಡ್ಕೊಂಡಿದ್ದೀರಾ?
ಪ್ಲೀಸ್ ಮುಂದುವರೆದ ಮೇಲೆ ಆದ್ರೆ
Wait. Heard the Learned Counsel appearing for the 1 HCGP, 2 emergent notice the statement of the complainant is as vague as vagueness could be, as the incident narrated is at 11:30, but he gets admitted to the hospital for treatment at 10 p.m., 1.5 hours before the incident. Therefore, there shall be an interim order of stay of further proceedings by the petitioner till the next date of hearing. Sorry. Yes. Next,
51. B report has been filed, Madam Chair.
B report,
Please.
same order, Kavya.
52.
Grateful.
The petitioner is before this court calling in question so and so. The proceedings instituted would clearly indicate, proceedings instituted through the private complaint would clearly indicate that the same is instituted for the purpose of recovery of money, which the apex court in the case of Lalit Chaturvedi reported in 2024 SSC Online SC page 171 has observed that such proceedings should not be permitted to be continued. Therefore, there shall be an interim order of stay. So on. Next.
This is a matter where we have sought for bail, my lords.
Bail.
How, this is a matter, my lords. 50 cases that were registered against him, he gets bail. 50 first, totally 110 cases, my lords, against him. 110 under the dodda plot alli, my lords. Different survey numbers. They say that he's cheated using various survey numbers by getting certain orders from the court. Now, my lords,
Oka court rejected the bail petition of the accused.
but that doesn't.
3-4 days back.
I'll just please I'll point out 3 illegalities, my lords, on the basis of which the entire arrest becomes illegal. My lords, the first is 41A notice issued to me, my lords. On the basis of 41A notice, I approach the concerned police. Police arrest me. Now that goes contrary to Satyendra Arthin's case, my lords, where you can't. 41A notice, if you are going to be complying with, you can't be arrested. Then, my lords, after I'm arrested, in that particular case, my lords, I get bail. After I get bail, I'm not released. They say in the other crime number, we show your arrest, we continue.
What to do if you have done 110 cases? Ondalla ಒಳಗೆ ಇರ್ತೀರಾ?
Illa. No, my lords, now the position of law is this. A person can be detained in jail only in one case.
Slightly modified. What is not there in this is, my lords, it is only an investigating officer who can give.
No, I'm only asking a simple question.
Please,
According to you, the petitioner has not done anything that is relatable to it. Sir, you're appearing for the complainant?
No, your lordships are saying petitioner is accused.
Petitioner is accused. That is what I'm saying. According to you, are for the government, right?
Please.
Now, your suggestion is that petitioner has not taken any decision or recommended anything that would become an offense as is that your submission?
Please. No, your lordship.
No.
No, I'm not on that. That's the legal position, my lord. In order to invoke 17A, that is a condition precedent, my lords. As your lordship pointed out. Here, I'm slightly one step further to entertain an application, my lord, under 17A. There should have been a preliminary inquiry.
That I understood.
Please.
What you're saying is, even for an application seeking prior approval under 17A, there should be a preliminary inquiry, as is necessary in Lalit Kumari and the SOP that is by the Government of India. That's your submission. So here there is no preliminary inquiry, and the competent authority himself has now acted, instead of referring it to the police for preliminary inquiry, as an approving authority, conducting inquiry himself and passing an order. That is your submission.
Second submission. And the third is, my lord, what your lordship felt, if the petitioner decision or recommendation and holding the post. So these are the 3 requirements, my lord. If I may read section 17A, so what is required is relative recommendation, decision by the public servant. Third, most important, in discharge of his official.
Correct. That is there. That is the soul of the. See, that is the soul of 17A. In discharge of his official duty, if there is anything recommended or any decision taken, this can be set into motion. That is the purport of 17.
And your lordship has said what is the object and purpose also of 17A is to protect the thing, and why it should not be abused also. Your lordships have dealt in Dr. Ashok and Pradeep Kumar and all those cases. Keeping those in mind, my lord, the question what your lordships will decide is, my lords, not only in this case, any other, I mean, on a principle of law, my lords, a trigger-happy complaints are filed day in and day out against various public servants to the competent authority, my lords. Then the nature of inquiry again, which ought to have been done, hearing the complainant, hearing the accused, then a decision being taken, my lord, that will send a very bad precedent or a proposition of law insofar as granting prior approval for investigation, my lord. It will defeat the purpose of section 17A. So therefore, investigating officer has to be only an police person, my lord.
Oh, you're coming at that.
I've been trying to come at that.
Yes. All right. Yes.
So therefore, my lords, ultimately, unless that report is there, that is what, I mean, that is what they say, the investigating officer forms an opinion. That ultimately, my lords, there may be, ultimately, my lords, it is for the competent authority to decide on the material, to grant or not to grant. He may not be bound by the
Report of the investigator.
investigating. He independently, he gives approval to, therefore, my lords.
Approval for what if there is already a report by the investigating officer?
No, therefore, he may accept it or reject it.
No, approval granted in case he wants to grant approval. For what does it grant approval?
Investigation.
It is already done.
No, he forms an.
You said investigating officer submits his report and seeks approval. For what does he give approval? For investigation again?
Please, my lord. So therefore, my lord, that is, I'll just put it. Preliminary inquiry is with regard to cognizance on offence which the investigating officer forms in view of the bar under 17A. He has to seek permission from the competent authority, and the competent authority gives approval to that. So without the approval, he can't investigate. That is why he seeks the approval.
You're trying to blow hot and cold. Now, prior to approval, you said there should be some inquiry or some report prepared.
That is what Lalit Kumar has said.
That makes sense. You're hinting upon Lalit Kumar's principles.
Principle. Then, my lord, your lordship, the lordship circular also may be kindly seen. My lord,
Lordship circular, High Court circular.
Your pursuant to your lordship's
order.
pursuant to your
Ashok,
lordship
yes.
judgment
Page-
in Dr.
Dr. V. Ashok or something, yes.
Please, my lord.
Page,
That is-
sir.
That is at page number, my lord, volume 1.
Citation, madam. Volume 1.
Page 260.
260.
In fact, my lord, what you're keeping in mind, the object of 17A, my lords, what your lordship said, 260, volume 1.
1 second, sir. Of the
Petitioner's paper.
Petitioner's volume.
petitioner's paper.
I'm sorry. I took it for granted that your lordships know all the page number, but I need not.
No, ಯಾವ ವಾಲ್ಯೂಮ್ ಅಂತ ಹೇಳಿದ್ರೆ ವಾಲ್ಯೂಮ್ ಆಲ್ಸೋ ಐ ಶುಡ್ ನೋ. 1 minute. Because that SOP you said was last 3 pages of that paper book.
So
That's why.
easy to remember.
ಹಾಗಂತ ಎಲ್ಲ ಗೊತ್ತಿರುತ್ತೆ ಅಂತ. Yes, sir. Page 260.
First, it refers to Priyanka Srivastava, my lord.
And Yashwant Sinha later.
Please, my lord.
Yes.
That is affidavit 173(1) and 173(4). I'll come to that, my lord. Here, page 261, my lord. The language, what your lordships has said at page 261 is, my lord, even if not to entertain such complaint if they do not comply with the following. That is, my lords, one is registration of the complaint, then prior approval in case of a prior complaint. Then last paragraph, my lord, these directions become necessary in the light of the fact that once the matter is referred for investigation, the police will have no choice but to register the crime. Therefore, such approval being appended to the private complaint is signed for maintainability of the complaint, except in cases where concerning disproportionate, which your lordship gave as an exception, such complaint shall bear the scrutiny so and so. So therefore, my lord, pre-requirement is compliance of 154 or 173, then 17A. So therefore, my lords, again, Manoj, here comes back to Lalit Kumari once again, Manoj, because it has, there is no application of mind or not application of mind, no preliminary inquiry, I put it, the language used by the Supreme Court, Manoj, no preliminary inquiry done in this matter, Manoj. And coming back to insofar as 154 and 173, your Lordship may kindly see on the 3 volumes were given by the Counsel for the Governor, the Solicitor General, Malad. If your Lordship sees, Malad, on those volumes, there is no complaint is given by respondent number 3. Respondent number 3 on 18th July and 25th July, Malad. And the immediately next day,
26th July.
26th July, immediately next day, prior approval is sought. So therefore, my lord,
Prior approval is sought and show cause notice is issued.
no,
on
the
26th.
points I'm trying to make here is, my lord, the question is,
No preliminary inquiry.
so therefore, he had not given an opportunity to conduct that inquiry. If he had given, we don't know whether the police officer themselves might have or might not have sought for prior approval.
No, if your submission is accepted, that permission was not given up to
Time.
sufficient time or whatever. 17A ಆದ್ಮೇಲೆ ಅದೇ ಆಗೋದು.
No, that's a different aspect, my lord. No, just because it's going to happen after 17A,
Not just because, only because.
No, only because, my lord, your lordship, go by to the Supreme Court judgment and the judgments of your lordships and the SOP cannot given a go by because it is likely to, the scope of that is entirely different. My lord, once the complaint 156.3, that's entirely scope. I'm not on.
No, if you're hinting on some inquiry, investigation should happen. Now, if the impugned order, I mean, like, by the impugned order, what is done is that only.
That he could not have done. That's the whole point, my lord. He is a competent authority, not a preliminary inquiring officer.
All right. Yes.
That is what is prohibited in law.
All right.
Sum and substances. So therefore, in fact, para 3 and para 9 of the written submission says, we have done preliminary inquiry. We have not given prior approval. Your Lordship may kindly see the written submission given by them.
By whom?
The Solicitor General, my lords.
Sorry?
All they say that we have done a preliminary inquiry as required in Lalit Kumari.
That is prior to giving approval.
By the competent authority.
Prior to giving approval.
By the authority.
So according to you, police officer should do that.
That's what the law says. Your Lordship, that is the requirement, my lords. So therefore, the application of.
Sir, 2 things.
Please.
If the crime is registered before the police, now if it or the lokaयुಕ್ತ or whatever it is, if it is touching upon or an amalgam of offence under the Prevention of Corruption Act and the IPC, prior approval will have to be sought.
Correct.
All right. The police officer or whoever files a prior approval before the competent authority to inquire or investigate. Permission comes, then he starts investigation.
Correct.
Starts investigation by what? By registration of a crime. All right. Now it is a private complaint. Straight away a private complainant goes before the court. He seeks reference under 156.3, now under 175 of the BNSS. Now if the matter is straight away referred, now say it is
not permissible.
No, that's what I'm telling you. If the matter is straight away referred for investigation to any authority, to jurisdiction police or to XYZ, no choice but to register the crime.
Correct.
So what happens to 17A?
So therefore, what?
By way of a private complaint, you obviate the process under section 17A and straight away get a crime registered where 17A, if it is before the police station or before the officer in charge of a particular police station, be it the lokaयुಕ್ತ, 17A would be required. All right.
Correct.
Now, 17A, the approval is sought before the competent authority. Here, the competent authority is the governor. Governor initiates certain process, not that day it is granted or what day it is granted. How it has been granted?
I'm not on that, my lord.
Yes. So according to you, Lalit Kumari had to be followed, preliminary inquiry had to be conducted. Now in the written submissions, the learned SG says that preliminary inquiry is conducted as contemplated under Lalit Kumari by the competent authority.
Which is not.
That is your submission.
It's virtually impermissible. He does not act as a investigating officer under law. He only is a approving authority what is sought by the investigating officer. That's the summons. And and what the whole case and the record shows that 25th was the complaint, 26th the file movement. He was heard, show cause notice issued, and reply sought for, and a decision is taken, clarification sought from the complainant, and then a decision is taken, which according to them is a preliminary inquiry is what they have done. Can I read para 3, Malot? It is of the written submissions.
Yes, sir. Page?
Page 9, para 3.
Ah.
It is submitted that the stage of granting approval under 17A of the Prevention and Corruption Act, it is not a stage where claims and counterclaims have to be weighed, or weight of the allegation is to be tested. It is submitted the only test that ought to have been adopted is whether there is an allegation which discloses the commission of a cognizable offence and apprehension exists that offence may have taken place, requiring an investigation to be conducted in accordance with law. Para 9, can I request, Madam?
Yes, yes.
That is at page number 12. It is submitted the order to further understand the scope of inquiry at the stage of approval for investigation. The principles laid down in the case of Lalit Kumari versus so and so, the Honorable Supreme Court ought to be referred to. In the case, the Honorable Supreme clearly held that once the cognizable offence is disclosed in a complaint, the FIR must necessarily follow. The said principle was laid down in the light of statutory provision and so and so, so and so, and the understanding that the empire is merely the starting point of a lawful means to uncover the truth of the matter. So the point here is, my lords, who has to do this preliminary inquiry? It's not in dispute according to them also, my lords, that preliminary inquiry need not be done. According to them also it has to be done. It says, I will do the preliminary inquiry. So therefore, my lords, there is no doubt that preliminary inquiry has to be done, even according to them. Then, my lords, page 14. Para 10.
All right.
I'm sorry.
Yes. No. For whatever is to be done, preliminary or otherwise, 70.
Please, Mr.
All right. Yes.
My lords, what my submission is, preliminary, as your lordship in the initial start, preliminary inquiry cannot be read into 17A.
All right. We'll consider. Yes.
Para 10. It is submitted that for the approval of investigation must be exercised guided by law laid down by the Honorable Supreme Court. It submitted in the case of information given to the police discloses the commission of a cognizable offence. The approval for investigation is to be granted unless the allegation appears to be wholly biased, motivated, and false. In furtherance of the aforesaid, it is submitted that the intent of the Honorable Governor was to ensure that proper investigation is conducted in the present matter, to merely uncover the truth in the matter and to not to take any specific sides.
So according to you, according to them, preliminary inquiry is conducted by the competent authority.
Please. Ultimately, what they said, we have followed Lalit Kumari. Then one of the important aspects, my lords, with regard to your lordships, I have held in Dr. Ashok's case also. My lords. In this case, my lords, insofar as respondent number 3 is concerned, my lords, as I pointed out, complaint is given, not even 24 hours is what was ought to be waited for before approaching the governor on the 26th. Immediately, my lords, he is heard on the same day. That is one aspect of the matter, my lords. Whether you could have heard
After a few days.
No, not after. Whether he could have been heard at all. At all. And what was thought to be argued, like the procedure need not have been followed. The question is, there is no such procedure. Rightly, my lord, there is no such procedure to hear a private citizen or a complaint. My lord, especially, my lord, when at the cost, allegations is made against an accused, whoever that may be, my lord, without his presence. And subsequently, my lord, issuing show cause notice, the whole procedure is not contemplated in the eye of law at all. When that being the case, my lord, the question, what your lordships will consider whether application of mind, principle of natural justice, reason order, I don't want to go into those aspects.
So you are at the root.
The root
It cuts at the root.
because the third, fourth, and the fifth complaint, my lords, here also I am not sought to give follow the requirement of section 154 or 173, my lords. If your lordship may kindly take the few dates in the written submission, my lords. Your lordship may kindly page 7, my lords.
Page 7.
Page 6, page 5, I'm sorry, my lords.
Oh, this table.
This table, which is forthcoming from the compilation of documents given
All
from the
right.
governor's compilation, my lords. On 18th July is the complaint given to the inspector of police, my lords, Lokayukta.
No, but it was argued that you had tendered an opinion saying that it is, they only have to seek the prior approval at 17A.
No, what, I'll come to my opinion later.
No, that's what I said. Because,
No, they have
no,
to.
now you are saying that police officer has to register, police officer has to seek permission.
No, what, they're slightly different what the opinion is given, what I'm submitting, my lord. Here, my lord, if they are complied with 154, my lords, as I submitted earlier, it is, he would have done a preliminary inquiry, then sought, as your lordship just pointed out, my lord, he would have, if it's a cognizable offense, he would have sought for a prior approval under 17A. The question is, my lord, whether 154 or 173 was sought to be complied. My lord, this 154 argument comes when private complaint is filed. But what my submission here is, my lords, the entertainment of the competent authority ought to have seen whether that procedure is followed prior to entertaining an application under 17A, my lord. The reason is this, my lord. If that was not followed, you should have seen that such a procedure is followed so that that material was with him. Here, my lord, 154.1 is not followed, or 173.1 or 173.3.4 also is not sought to be.
151.
1 and 3 has not been. No, so I'm understanding. Please, ma'am. So therefore, my lord, to entertain that application also, application 17A, my lord, this crucial aspect, whether the compliance of 154, my lord, was done, or 173, 1 and 4 was done, was very crucial. If that was not done, my lord, it ought to have been returned back, saying that comply with the said procedure, then you file an application. In fact, insofar as Pradeep Kumar is concerned, my lord, that is respondent number 5, no such complaint is given at all. And insofar as respondent number 4 is concerned, my lord, application is filed subsequent to filing a complaint before the competent authority. And the competent authority has considered the application dated 5th July 2024, which pertains not seeking prior approval, but seeking CBI inquiry. So therefore, my lords, insofar as application of respondent number 4 for grant of sanction was not there, neither in the file of the competent authority, the Honorable Governor, my lords, or in the statement of objection. So therefore, my lords, the application sought for ought to not been entertained on this count also.
Yes.
Then finally, my lords, one of the point coming to now the aid and advice, my lords.
163.
163. Insofar as courts, MP police establishment, and they've all said, my lord, the discretion is with the governor. The question is, what is this discretion? How he has to exercise this discretion? For example, my lords, on the basis of if the aid and advice or there is material, we'll take a situation, my lords, where recommendation is given, the aid and advice is to grant sanction, and the same is rejected. It can work both ways. In this case, my lords, the advice is not to grant sanction, it has been granted. There may be cases, my lords, where recommendation is to the other.
Not to grant sanction, but sanction is. But sanction is, to grant sanction, sanction is not granted.
Not granted.
All right.
So therefore, my lord, this discretion is not his absolute power or absolute discretion which he can exercise. This is limited to what has been held by the Supreme Court in MP Police and Justice Punchi's judgment and Nawab Rabia and all these judgments. Ultimately, I just like to write 2 paragraphs of the judgments, my lords. My lordship may kindly take to page number, my lords.
48.
Please. Page 41 for a moment, my lords.
The discretion begins there. Your submission is at page 48.
Okay. Note on points with regard to.
Yes.
So therefore, my lords, with regard to limited discretion, narrow scope of discretion, reason and caution, my lords, keeping that in aside, my lords, I'll just, where is that paragraph? Your lordship may kindly turn to page 55, my lords. At point number 4.
MP Police.
Which has been reiterated in AG para 4, my lord. It is pertinent to note, as evident from the impugned order and the materials put forth by the governor, there has been assumption of bias contrary to the legal principle established in MP Police establishment, Nawab Rabia, and so on and so on. So the exception carved out in this landmark judgment for when a governor may act against the advice of the Council of Ministers have not been addressed or satisfied in the present case. The impugned order and the material produced by the Honorable Governor fails to provide any substantive reasons from deviating from the aid and advice given by the Council of Ministers, nor does it demonstrate how the Cabinet's recommendation against granting sanction was irrational or unsupported by material evidence or suffered from bias. Furthermore, the order lacks a reasoned explanation to establish its own rationality or to show that it is based on through consideration of relevant materials. This absence of reasoning, coupled with apparent haste in the decision making, raise serious question how the propriety and legality of the impugned order potentially infringes upon the constitutional scheme and governance principle of federalism.
Yes.
Your Worship may turn to page 43, Malats, for a moment.
Yes.
The 43 last paragraph, Malats, 4.2.15.
Yes.
Explains, referring to Shamsher Singh and M.M. Punchi's commission's report, Malats. It's just been culled out over there.
Yes.
Which page 43 highlighted portion, Malats. Thus, the scope of discretionary power as provided in exception to clause 1 and in clause 2 of article 163 has been limited by clear language of 2 clauses. It is an accepted principle that in a parliamentary democracy with a responsible form of government, the power of the governor as a constitutional or formal head of the state should not be enlarged at the cost of real executive with the Council of Ministers. The scope of discretionary power has to be strictly construed, effectively dispelling the apprehension, if any, that the area of exercise of discretion covers all or any of the function to be exercised by the governor under the Constitution. In other words, Article 163 does not give the governor a general discretionary power to act against or without the advice of his Council of Ministers. This area of exercise of his discretion is limited. Even this limited area, his choice of action should not be arbitrary or fanciful. It must be choice dictated by person, actuated by good faith and tempered by caution.
Prudence, caution. All right.
So, Malad, this is the, so therefore, Malad, the Lordships will see, Malad, whether the impugned order comes within the 4 walls of this aspect. So therefore, Malad, the reasoning that the impugned order says it is my discretionary because there is bias apparent and evident is not a ground. As already pointed out, Malad, it should be by reasons with which the reasons should be in the order itself, not in the file, Malad. I would just like to take your Lordship to the file for a moment, Malad.
Which file?
The governor's file.
Right.
Just I'll end with that, my lord. Just want to point out 2-3 aspects
Yes.
in that, my lord.
Madam, ಕೊಡಿ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕಾಪಿ ಕೊಟ್ಟಿದ್ದಾರೆ, ಕೊಟ್ಟಿಲ್ವಾ?
Volume
No, it's in volume.
1.
That's the order.
Oh,
Include
no, order sheet.
all.
Proceeding.
Yes, yes.
If
Page.
page, my lord, page 1, my lord.
Ah,
If your lordship sees, my lord, the reference subject is sanction for prosecution, my lord, of so and so, so and so. Petition, so and so, dated 26/7. Kindly produce petition by so and so, serial number 1. Then next page number 2, my lords. Please pursue papers, pre-paras, the complaint addendum. Then next at page 3 on right on top, my lords. I have heard so and so in person and gone through the petition and supporting documents submitted by him. Prima facie, I am of the view there might be irregularities and misuse of power. Hence, show cause notice to so and so within 7 days. So this is what the preliminary inquiry sought to be done, my lord. Then can I request, my lord, page 7. Speaks about, my lord, the reply given by the petitioner, then the proceedings. Then last at para 20, my lords, put up along with the comparative statements of petition, Chief Minister.
sorry. Ma'am.
They recently contested me out in the elections also.
ಅದು ಮಾಡಿದ್ರಾ?
ಏನ್ ಮಾಡೋದೇನಿಲ್ಲ.
ಗೆದ್ರ?
ಅಲ್ಲ ಕೆರೆ ನೀರನ್ನು ಕೆಳಗೆ ಚೆಲ್ಲದ್ರು ಅಷ್ಟೇ.
ಅಲ್ಲ.
ಈ ಲಾಸ್ಟ್.
ಗೆದ್ರ? ಇಲ್ವಾ? All right.
ಎಲ್ಲೋರು ನಮ್ಮ ಎಲ್ಲೋರು ಆ ಕಡೆ ಹೋಗ್ತಾರೆ.
All right. Yes.
Please.
12th. ಅವತ್ತು ಪ್ರಸನ್ನ ಕುಮಾರ್ ಮುಗಿಸ್.
I shall. Great.
Same conditions ಅಲ್ಲಿ chamberಲ್ ಮಾಡಿ all conditions.
15 minutes. Hate speech.
ಒಂದು ನಿಮಿಷ.
Entry order is there, can be taken on 19th.
List on 26th. Entry order subsisting shall continue till the next date of hearing.
34 also, same petitioner.
ಯಾವುದು?
34.
ಬರ್ಲಿ ಅಲ್ಲಿಗೆ.
Oh.
Yes.
Second respondent filed a complaint on behalf of the third and fourth respondent.
Respondents ಅಲ್ಲಿ entry order ಇದೆಯಾ?
Interim.
Same 26th IO.
My lords, short accommodation.
Entry order ಇದೆಯಾ?
Yes, my lords.
26th IO. Next.
This case. It's a civil case, please, my lords, blown out of proportion. What transpires, my lords have captured the whole issue, please, my lords, in the interim order.
Entry order ಕೊಟ್ಟಿರ್ಬೇಕು.
ಕೊಟ್ಟಿದ್ದೀರಿ. What transpires, my lord, they have sold the property to us for consideration of 9 crore rupees. Consideration is passed on. Thereafter, please, my lord, they go institute a suit, my lords, for declaration and injunction. Interim orders are not granted. After that, my lord, they come up, my lords, before the police to say, lords, I am making development.
There is a detailed order, right?
Please, please. It will only cover, the same thing will have to be.
Respondent ಬರ್ಬೇಕಲ್ಲ.
ಬಂದಿದ್ದಾರೆ ಸ್ವಾಮಿ, somebody.
ಎಲ್ಲಿದ್ದಾರೆ?
They gave us the objection statement also.
All right. Learned counsel for the respondent seeks time to file statement of objections. List on 26th. Interim order granted earlier, stands extended to the next date of hearing. Next.
Please, grateful, please.
ಇದೇನ್ ಮತ್ತೆ?
Date ಕೊಟ್ಟಿದ್ದು.
Minutes appearing for proxy counsel, minutes. Senior is in the out of station.
Out of station? Hello, what is this?
Not the one, what the order has been not observed by your lordship, see, not 195 capital A. You want whether 195 is a bar, may not.
Oh, this I
Threatening
granted an
witness-
interim order.
Threatening witnesses. But I'll just bring to your lordship kind notice, maybe heard on some
Senior
other day.
ಇಲ್ವಂತೆ?
Alla, same, it
We'll
can
take
be
it
heard
on.
on some other day, but your lordship may have to may not consider 195 capital A of CRPC.
ಅದೇ ಕನ್ಸಿಡರ್ ಮಾಡಿ.
ಅಲ್ಲ 195 ಮಾತ್ರ ಮಾಡಿದ್ರು, 195 capital A ಮಾಡಿಲ್ಲ.
ನೋಡಿ ಇಲ್ಲಿ ಆರ್ಡರ್.
But 195.
Entry order ನೋಡಿ.
I'll,
It's a 4-page entry order.
please, I'll,
195 capital.
then I'll prepare myself not on this
Exactly, sir.
grounds.
No, whatever, 195 capital A is introduced later by way of an amendment.
Please.
That does not take away the procedure to be followed under 340. No procedure is followed. Who has to
complaint
take,
really-
and which court has to complain? You have gone and registered the complaint before court at Dharwad. Everything has happened here before the special court. How do you do that?
ಅದ್ರಲ್ಲಿ ನೋಡೋಣ ಇಲ್ಲ.
ಮತ್ತೆ ಅಷ್ಟೇ. I remember what I have granted. Yes. Heard, the list the matter on 26th interim order subsisting shall continue till the next date of hearing.
Please.
Nodi, I have,
Yes,
yeah, interim order, it's a detailed interim order that I have granted, just see it.
But 20.
20 minutes I appeal for the petitioner. Minutes senior appears, he's on his legs. Minutes, your Lordship may kindly have it on Monday minutes coming.
Then we'll vacate the interim order.
Minutes, he is. he
List the
appears-
matter on 26th interim order subsisting shall continue till the next date of the hearing. Yes, sir.
One. Paying for petitioner minutes.
Non-compliance of office objections.
1 week time maybe.
ಓ ಇದೇನಾ ನೀವು ಬೆಳಗ್ಗೆ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದು? Yes. A week's time is granted to comply. Weeks, ಏನ್ covered ಏನು?
ಇದಲ್ಲ my lordship, ಇನ್ನೊಂದಿದೆ court
ಇನ್ನೊಂದಾ?
measurement.
Week's
26.
time is granted to comply with the office objections. Interim order subsisting shall continue till the next date of hearing. ಇದು interim order ಇದೆಯಲ್ಲ ಫೋನ್? Yes, 26th IO. Oh, 21, sorry. 20 ಹೇಳಿದ್ದ ಈಗ? 21. No, 1 week time is granted to comply with the office objections. 26th, yes, Pawan.
3 and 153A.
Correct. Take ಕೊಟ್ಟಿದೀವಲ್ಲ?
Yes, Lord. While my Lord distributing the Mantrakshara of the Ram Mandir.
ಮಂತ್ರಾಕ್ಷರ.
Yes,
Really,
Mantrakshara of Ram Mandir.
ಚಾರ್ಜ್ ಶೀಟ್ ಫೈಲ್ ಆಗಿದೆ.
Charge sheet has been.
ಸ್ಟೇ ಇದ್ದಾಗ ಹೆಂಗಾಗ್ತದೆ ಚಾರ್ಜ್ ಶೀಟ್?
Before he files the petition itself, charge sheet came to be filed.
Then why have you not stated that?
No, my Lord. It is transferred from Dharwad bench to Bangalore bench. my
All
lord.
right.
Yes, my Lord.
ಇಲ್ಲಿ ಟ್ರಾನ್ಸಿಟ್ ಆಗ್ಬೇಕಾದ್ರೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ರ ಇಲ್ವಲ್ಲ?
Charge
My
sheet
lord,
filed on
ಮತ್ತೆ?
13/2/2024.
13?
Sir,
13/2/2024.
that is after the filing of the petition before the grant of the interim order.
Because my Lord, I have made my Lord application immediately before.
ಚಾಲೆಂಜ್ ಮಾಡಿ ಸರ್.
Please, my Lord. In the
Interim
meantime,
order ಇರೋದ್ರಿಂದ amend ಮಾಡಿ.
please.
Yes. Counsel for the learned additional SPP submits that the charge sheet has been filed prior to the grant of the interim order, albeit after the filing of the present petition. Therefore, in the light of the pendency of the interim order, I deem it appropriate to permit the petitioner to raise a challenge to the charge sheet.
Interim order is only to not to precipitate, not.
Whatever, sir. So and so. List the matter on 26th. Needful be done by then. Any interim protection subsisting shall continue till the next date of hearing.
Please.
Next.
My Lord, next one is my Lord 153(1) and 153(2). Though there is my Lord such provision
ಇಲ್ಲೂ
is
ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದೀರಾ?
illa.
Interim order ಇದೆಯಲ್ಲ?
But no provision, my Lord, available under the offense under section 153(2). But even though there is no definition.
ಅದು ಪಾರ್ಟ್ ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ, ಪಾರ್ಟ್ ಬಿ ಗೆ they indicate it as 2. 506 ಅಲ್ಲಿ there is no part, there is no B, but they say 506B, it is part 2.
Correct, my Lord, but here 153(1) and 2
ಅದು ನೋಡಿ.
simultaneously, that is not
Stay
correct. my
ಉಂಟಲ್ಲ?
Lord. Stay unto.
Yes.
Stay.
My Lord, this is also my Lord.
You should correct them. 506B ಅಂತ ಹಾಕ್ಬಿಡ್ತೀರಾ? It's
ಕೆಲವು
not
ಕಡೆ B ಅಂತ
part
ಹಾಕ್ತಾರೆ,
2.
ಕೆಲವು ಕಡೆ part 2 ಅಂತ.
The
Part
absence
2
of-
actually, because 506 is a non-cognizable
Yes, ma'am.
offense. If you see part 2, it is a cognizable offense.
Then my Lord, there is no mens rea here, my Lord. There is no mens rea. He has a my Lord
List on 26.
has a 7-time MP of the my Lord
ಅದಕ್ಕೆ
constituency.
ಮೆನ್ಸ್ರಿಯ ಇರಬಾರ್ದು
Just
ಅಂತಿದೆಯಾ?
represented the.
ಅಲ್ಲ ಅದಕ್ಕೆ ಮೆನ್ಸ್ರಿಯ ಇರಬಾರ್ದು ಅಂತ.
ಏನು ಮಾಡಿಲ್ಲ ಸ್ವಾಮಿ.
ಮತ್ತೆ
Just-
wait. List on 26th interim order subsisting shall continue till the next date of hearing. Yes.
24.
I appear for the party. This is 153 capital A minutes.
All these 153 years will
Two
take
group.
one day and finish it.
No, this is through WhatsApp malad. Well, is that
Day ಕೊಟ್ಟಿದೀವಲ್ಲ sir.
5/4/2020.
There's a detailed orders.
Yes. Of course, your lordships also interpreted in Raja Singh Thakur's case. 2
153.
groups should be a sine qua non for.
Yes, sir. That is
applicable.
following the judgment of the apex court.
Yes, yes. And
Javed
so
Hajam-
far as the WhatsApp is concerned,
Javed Hajam and
Javed Ahmad.
Javed Hajam and Shiv Prasad Semwal,
Yes.
about 2024. Yes. Heard the learned senior counsel appearing for the petitioner. List on 26th, the interim order granted on 5/4/2024 shall continue to the next date of hearing. Yes, next.
Petitioner's
ಇದನ್ ಲೇಖ.
Lord, some defamatory article, my lord, was published in a newspaper. Allegation that he, my lord, give a bite in the media. That is the allegation, my lord. And my lord,
Begun to give bites.
we are ready with the matter, my lord.
Yes, sir. You're ready with the matter. Why are you
Because
ready?
interim order was granted earlier.
ಇದೆ interim order.
Ready?
Ready na?
Ready.
ಹೇಳಿ sir. Yes, sir.
Lord, petitioner was a deputy speaker, my lord, from 6/3/2018 to 17/3/2020, my lord.
ಇದು ಅವಾಗಿಂದ ಇದು.
Avagin incident, cognizance taken later, my lord.
All right.
My lord,
Complaint is registered when time?
yes, my lord, it was registered in 1 month, my lord, after the incident, alleged incident taken
All
place.
right.
But the background is this, my lord. Petitioner was a deputy speaker, against which, my lord, the respondent makes reckless allegation of, my lord, land grabbing and all. Lord, for which, my lord, he lodges a complaint, my lord, and that was registered as NCR. Then, my lord, the respondent was called to the police station and he was advised, my lord, and then endorsement has been issued to the petitioner. Lord, suppressing all these facts, he files this present complaint, my lord, on 25/11/2019, 13/12/2019, my lord. The NCR was, my lord, closed on, my lord, 25/11/2019. But the allegation is this, my lord, the paper publication, which is produced, my lord, at annexure, my lord, page 58.
Yes.
My lord, right side. Lord, this is, my lord, stated in the context, my lord, where he made reckless allegations, and, my lord, NCR was registered and the endorsement was given. He says, my lord, ಹುಚ್ಚ ಮೂರ್ಖ ಅಜ್ಞಾನಿ ಏನನ್ನ ಬೇಕು ಅರ್ಥವಾಗುತ್ತಿಲ್ಲ. This is the only allegation, my lord, against the petitioner.
How can you term someone as mad?
Lord, this is not the, he is saying ಹುಚ್ಚ ಅಥವಾ ಅಜ್ಞಾನಿ ಏನನ್ನ ಬೇಕು ಅರ್ಥ ಆಗುತ್ತಿಲ್ಲ, because he makes reckless allegation without there any basis. And, my lord, he simply, my lord, it is like a hit and run case, my lord. He gives
500,
499 500.
Correct, 499.
My lordship, first contention is that that I have not filed affidavit before the trial court.
ಅದು ಹಾಕಿದ್ದೀನಿ ಅಂತ you
ಹಾಕಿದೆ.
take it as your file.
Yes.
Yes, don't get into that contention. ಆಮೇಲೆ
Second contention is that I have not taken the sanction.
that also you have taken.
No, sanction is not required because there is no nexus between the press meet and the discharge of his
Discharge of
official duty.
official duties. ಆಮೇಲೆ
So, third contention is that the trial court has not taken the cognizance and proceeded to record his own statement. In this regard, I want to cite a citation, my lordship.
citation ಕೊಡಿ.
ಹೌದು, ಸತ್ಯಸಾಯಿನ. Page 25, 27, my lordship.
My judgment only you are giving.
This one.
My order, sir.
Yes, my lordship.
Pradeep Odeyer, sir.
Yes, my lordship.
Curable defects.
Curable defect, and there is no necessity of mentioning in the order sheet. It is presumed to take as a sanction has been taken.
ಆಮೇಲೆ
And fourth contention is that these words doesn't fall under the definition of 499 and 500. He cannot call any person as a mad idiot.
Idiot.
Yeah.
ಎಲ್ಲಿದೆ?
ಹುಚ್ಚ
ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ?
ಮೂರ್ಖ,
Okay.
Agnani. And it sends a wrong message to the society.
Correct.
Hence, I pray this honorable court to
Dismiss the petition. Yes, sir.
Lord. Now, my lord, the grounds urged are, my lord, one is, my lord, this is filed as a, my lord, counter blast and afterthought. Number one, my lord.
But the statements are statements, they are facts. Facts are stubborn.
I'll come to, my lord.
Yes.
Now, my lord, that is number one, my lord.
Yes,
The
sir.
second ground is, my lord, the complaint has been filed with the oblique motive in order to harass and humiliate and tarnish. But
ಯಾಕೆ ನೀವು ಹೇಳೋದು oblique motive
ಅಲ್ಲ, ಅವ್ರು ಫಸ್ಟ್ ಕಂಪ್ಲೇಂಟ್ ನಮ್ಮ ಮೇಲೆ ಹಾಕಿ he makes reckless allegation and I, my lord,
ನೀವು ಇನ್ಸ್ಟಿಟ್ಯೂಟ್ ಮಾಡಿಲ್ವಾ?
no, I gave a complaint, my lord, police that was registered as NCR.
You should have filed a private complaint for defamation.
No, my lord, he also holds a press conference against me, my lord.
ಆಯ್ತು, ಆಲ್ರೆಡಿ
Sir,
he
this is-
also ಬಿಡಿ, ನಿಮ್ ಮೇಲೆ ಅಲಿಗೇಷನ್ ಇದೆ, ನೀವು ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿಲ್ಲ. You have to answer that.
Yes. But my lord, he gives a statement before the police.
4 grounds, 4 replies.
No, my lord.
Straight reply, straight answer.
No, my lord.
No beating around the bush.
No, my lord. There is no independent witness, my lord, supported the claim or contention of the complainant.
It's a press conference,
No, my
public
lord.
domain.
Lord, now the sworn statement has been recorded, which is very bald and vague, my lord. Kindly see, my lord, page.
Hmm.
55 is, my lord, 52, CW1, my lord, the complainant. Lord, he says, my lord, only, my lord, the defamatory statement has been made. Only that he says, my lord. And, my lord, there is a difference between, my lord, the date given in the complaint and also, my lord, in the sworn statement. The complaint, my lord, he says, my lord, on 16th, the press meet was held. Then, my lord, in the sworn statement.
Press meet is a matter of fact. ಯಾವತ್ತಾಗಿದೆ and date mistake ಆಗಿದ್ರೆ that does not absolve you. ಆಮೇಲೆ.
But, my lord, it is a bald sworn statement where there is, my lord, no ingredients has been attracted to attract, my lord, section 499. Next, my lord, the CW2, who is supposed to be independent witness, my lord, he should have stated two things, my lord. The complainant, my lord, is a reputed person and his reputation is tarnished by virtue of the alleged defamatory statement given.
Oh.
He has not stated, my lord, anything, only vague statement. Kindly see page 55 for a moment, my lord.
So only a reputed person can be,
No, my lord,
reputed person's image can be tarnished.
not so, my lord. He should, my lord, state two things, my lord. Independent witness should come and say.
You mean to say
Is a
reputation is only of a reputed person?
Reputation was there and it has been tarnished. Now, both is missing, my lord, in this case. Kindly see page 55. It's a vague sworn statement, my lord. Therefore, my lord, my respectful submission is even 202 is not complied.
ಏನ್ 202 is not? What 202 is not?
My lord, the cognizance is taken by the special court. But, my lord, accused, my lord, while issuing, my lord, process, he has not complied 202. Inquiry has not been conducted.
Why
properly.
inquiry?
My lord, he is residing outside the jurisdiction. My lord, the complaint was earlier filed before the regular magistrate. Then it was shifted
Transferred to the special court.
special court, my lord. But now, my lord, while issuing
Special
the-
court is not there everywhere.
my lord, now the
There's only one.
yes, my lord.
So the 202 goes next.
My lord, the inquiry as contemplated, my lord, in
Not
order to
necessary, sir.
satisfy himself
There is
that, my
only
lord,
one court.
in order to satisfy himself that, my lord, the matter requires, my lord, issuance of process. That has not satisfied, my lord, is my respectful submission. Lord, the other ground is counterblast, my lord. The moment I filed a complaint, he filed this private complaint. That is one. My lord, another ground is, my lord, suppression of fact. The complaint which was filed earlier, my lord, against him is not, my lord, nowhere mentioned in the complaint or in the sworn statement. That is another aspect. And, my lord, delay of 30 days is there, my lord. That is another one. Lord, the other ground is, my lord, the ingredients are not attracted so far as 499 is concerned, my lord.
Why?
There are-
You can call anybody this, is it?
No, not so, my lord. This is in the context of, my lord, case and counter case, and after thought, my lord, it has been filed. And, my lord, here there are few judgments, my lord, which says even calling merely by naming or calling something like this, my lord, does not attract, my lord, 499 unless, my lord, there is an intention to, my lord, defame.
All right, let's see. Yes.
And he is a habitual complainant, my lord. He has lodged many complaints, my lord, against so many people.
List on
He is a
19th,
politician,
heard
my
the
lord.
learned senior counsel, so and the council. List on 19th for dictating orders.
Not only one
Interim order subsisting shall continue till the next
one
day.
submission, my lord. There is one judgment we are relying upon, my lord. We placed on record. It says, my lord, politicians are, my lord, they should be
Thick-skinned.
thick-skinned. Yes, my lord.
Oh.
He is
I have seen that
my lord, he
thick
claims a politician, social worker, my lord, and also, my
Vinod Kumar has
my
given the
respectful submission
thick-skinned
is, my lord.
judgment.
He's a troublemonger, my lord. He invited trouble. That is my respect.
All right. Yes.
Grateful.
List on 19th dictating orders. We'll continue 2:30. ಹಸ್ಬೆಂಡಾ? ಎಂಟೈರ್ ಫ್ಯಾಮಿಲಿಗೆ ಸ್ಟೇ ಇಲ್ವಾ? ಆಯ್ತು, ಮಂಡೇ ಕೊಡಿ ಅದು. ಇವತ್ತು 2022 nobody has moved. I have got all the matters listed. Nobody is interested. 2 years in ಹಂಗೆ ಇರುತ್ತೆ, ಸಡನ್ ಆಗಿ ಅರ್ಜೆನ್ಸಿ. What application is this? When did you file it? Judgment post ಆದ್ಮೇಲೆ? Then? When did you file it, sir? That's all right. At what stage did you file it? ಏನ್ ಪೇಪರ್ ನೋಡಿಲ್ಲ, ಏನಿಲ್ಲ, ಸುಮ್ನೆ ಒಂದ್ ಮೂವ್ ಮಾಡೋದು. ಕೊಡಿ 12th ಕೊಡಿ. Vacating interim orders, ಯಾವ applications, give all those applications. Give all the applications where vacating stay is filed. Vacating stay. Wait. Vacating stay applications kodi alla. I will assign dates for that. Yes. Vacating. Fresh matter alla Monday kodi, matte move madbidi. Yes. Yes, Ravi Shankar. Kodi. Vehicle release naale tagoli. Give it. Yes.
DA case, request for tomorrow since all the matters coming tomorrow.
We'll see. Give it. Yes. All the matters ಮುಂಚೆ ಇದ್ದಿದ್ದು, ನೀವು ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದ ತಕ್ಷಣ ನಾಳೆ ಬರ್ಬೇಕು ಅಂತಿಲ್ಲ.
No, it is all.
Give it. We'll see. Parval. Yes, sir. New DA cases, whatever is filed, madam.
My lords,
New DA cases, whatever is filed, don't post them tomorrow. We'll
Lords,
post it next week. Give it. Yes.
498 matter, husband and family members who are residing in Coimbatore.
Are pending, sir.
It's like we have filed an IA number
Fresh
20.
or pending?
Pending, sir.
Pending. Well, it has come once already.
Yeah, on 2nd of this month it has came, we have filed an amendment application.
It has come, not came. Yes. Give it.
May post it on Wednesday, my lords.
Give it. Next week haki alla.
Sir, it's urgency, sir.
Oh,
Staying in
urgency.
Coimbatore.
Why day after tomorrow? ನೀವೇ ಡಿಸೈಡ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ ಡೇಟ್ ಇಲ್ಲಿ? ಯಾರಿಗೆ ಅವ್ರಿಗೆ ರಿಕ್ವೆಸ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? Give it on Monday. Yes.
Well, a small submission, please. I was
MMRD Act covered by judgment.
Maybe, sir. Give it fresher. If it is fresh matter, please don't wait. Give the memos.
Not
No, this week, all on Monday.
particular case now will be listed tomorrow.
Maybe, sir. Tomorrow you move the matter when the matter is listed.
blood.
Yes. Give all the memos. Fresh matters, please give all the memos. I'm not going to take anything for this week. Give it. Yes. If it's pending, wait.
This one submission, please.
Give it. No problem, sir. So what, sir? Can't help. What were you doing till 17th August? Yes.
One submission, please, my lord.
Give it. Monday, all Monday, give it.
Can I submit, please, my lord?
Ella Monday ge kodi. Fresh matters, I'm not taking anything, sir. All on Monday. Everything on Monday, give it. No, sir, Monday. Can't help. Yes. Next.
Small submission, please, my lord.
ಎಲ್ಲರೂ ಹೇಳಿದ್ರಾಗಲ್ಲ. ಮೆಮೊ ಹೇಳಿದೀನಿ. Whichever is fresh matters, please give it.
My lord, this is.
Please give all the fresh memos.
In the family code. That's the.
Give that. Yes. At 2:30 ತಗೊಳ್ಳಿ. 2:30 ತಗೊಳ್ಳಿ.
Your lordship permits. My lord, I've been tried and convicted already under the Provident Fund Act. My lord, on that appeal is pending now. My lord, on the same facts, my lord, I've been charge sheeted for an offence under 406. That is the problem, my lord. Your lordship may assign any date, my lord.
Pending matter.
Not pending, my lord. Fresh matter.
Monday, sir.
Monday, please.
All Monday, I've told you, ಮತ್ತೆ an assignment of dates there.
Grateful.
Give it.
Monday.
Withdrawal of the amount, my lord, under petition and section.
Take that tomorrow. Withdrawal of the amount tomorrow. Yes. Respondent tomorrow. Yes.
Who has been arraigned as an accused, stay order has been granted.
No problem.
The verge of retirement. The date may be.
Next week. Yes.
One submission, my lordship. 2023 fresh matter, my lordship.
Monday.
9 memos, my lordship, not being listed so far.
This is the 10th. Give it. Monday.
My lords, may I make a mention?
Give withdrawal, sir.
My lords,
ಯಾವ ಬೌನ್ಸ್ ಆದ್ರೆ ಏನಂತ? ನೀವು ರೆಸ್ಪಾಂಡೆಂಟಾ? ರೆಸ್ಪಾಂಡೆಂಟ್ ಈಗ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕಿದ್ದೀರಾ?
ತಾಲೂಕಲ್ಲಿ ಇದಾರೆ ಅಂತ ಓಲ್ಡ್ ಪೇಟರ್ಸ್ ಕೊಟ್ಟು ಮಾಡಿ ಎಂಟ್ರಿ ಮಾಡುತ್ತಾರೆ.
ಕೊಡಿ, ಅದು ಯಾವ ವರ್ಷದ ನೋಡಿ ಅದು ಹಾಕಿ.
Fresh matter, my lordship, to be listed today.
Monday.
I request
Why?
date Monday ಬರ್ಲಿ.
Why today?
Like today it was scheduled. It was
Monday it will come, sir. Give it. Monday ಅಲ್ಲ. Monday is a holiday. Tuesday. Yes.
one pending
my
matter.
lords, in this
It is both.
cryptocurrency exchange, my lords. FIR was filed in 2021, my lords. Now, my lords, my bank account has been attached, my lords. My name is not disclosed in the FIR itself, my lords.
Monday.
My lords, bank account, salary account is.
ಯಾವಾಗ ಆಯ್ತು?
23/8 ಆಗಿದೆ ನಂದು.
23/8
Please.
ಸ್ಯಾಲರಿ ಡೇಟ್ ಆಗೋಯ್ತು. ಇನ್ನ ನೆಕ್ಸ್ಟ್ ಏನಿದ್ರು ಅಕ್ಟೋಬರ್ಗೆ. ಸೊ ಗಿವ್ ಇಟ್
Difficult is so tomorrow at least.
Monday.
Tomorrow if it's possible, my lords.
Give it on Monday. They'll come on Monday. Madam, ಯಾವ್ದು Tuesday, no memo should be held. Post everything.
Lords, matter for being spoken to, my lords had cost.
Tomorrow.
My lord, this
Being
is
spoken to, my lord, this
Tomorrow. In being spoken to na. 2:30 ಯಾಕೆ sir? Yes.
Respond number 2 has filed a complaint.
So what? Matter ತಾನೆ. Monday, yes.
my lord.
Thursday ಎಲ್ಲ ಇವತ್ತು ಡೈರೆಕ್ಟ್ ಆಗಿ ಹಾಕಿದೆ, ಯಾವ್ದು ನಿಲ್ಸಿಲ್ಲ. ಸೊ ಮಂಡೇ Thursday ಏನ್ ಬಂದಿಲ್ಲ.
My lord, this is
Lordship,
Monday.
Lordship in this matter, is pending matter.
ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಕೊಡಿ ಸರ್.
ಅಲ್ಲ, it is
ನಾ ಈ ವಾರದಲ್ಲಿ ಏನ್ ತಗೊಳಲ್ಲ, ಕೊಟ್ಬಿಡಿ.
Lordship in
10ನೇ ಮೆಮೋ ಆದ್ರೆ ಈ ವಾರದಲ್ಲಿ ತಗೊಳಲ್ಲ, ಕೊಡಿ. Yes.
Lordship in pending matter, it is notice is ordered, on 19/7 it is posted. On that day, since notice is not served, await is ordered.
ಆಯ್ತು.
Thereafter it is not posted. I have
Correct.
moved to 3 memos.
So what?
Lordship, there is urgent.
No, give it, yes. Birth code, when do you want?
My lord, this is the
Please.
this is the first matter.
Monday.
I moved 3 memos, my lord.
10th ಆದ್ರೂ Monday.
ಅಲ್ಲ, Monday ಬರ್ಲಿ, Monday
Sir, no precedence like that, give it, yes.
My lords,
ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಮುಂಚೆ ಬರುತ್ತೆ.
my lord, one FIR was stayed, my lord. Another FIR has been registered against the same petition.
Monday, sir.
For the same fact, my lord. My lord.
Huh?
Government servants are suspended for the by registering non-cognizable.
Government servants are suspended. Why are you moving this court?
In FIR is registered for non-cognizable offense, my lord. And we have approached the KIT. KIT has refused to stay, granting stay.
So?
That FIR is registered
So?
for non-cognizable offense.
You were inside for 48 hours?
My lord, no,
Were you arrested for beyond 48 hours?
no.
ಮತ್ತೆ ಯಾಕೆ why were you in suspension? Mere registration of the crime will not put you under suspension. No.
Day after
Challenge it, service ಅಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ, ಇದಕ್ಕೆಲ್ಲ ಬರಲ್ಲ, ಕೊಡಿ.
is registered.
Monday.
Day after tomorrow, KIT is
Monday,
KIT is tomorrow, my lord.
ಏನ್ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್ಸ್ ಅಂದ್ರೆ suspension is not dismissal, give it, yes.
Your lordship. Fresh matters, my lordships.
Monday.
Petitioner is student, my lordships.
Monday,
Your lordships,
all for Monday.
lordship,
Give it, which year? Give all the memos.
Pending, my lord, 2023 matter.
Thank you, give it, yes.
Interim order granted, subsequent interim order is not extended, my lord. Now
That's all right, we'll see, give it, yes.
charge sheet ಹಾಕ್ಲಿಕ್ಕೆ ಅವ್ರು ಕರೀತಾ ಇದ್ದಾರೆ, ಅದಕ್ಕೋಸ್ಕರ.
ಅದ್ ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಯಾವ್ದು ನಾಳೆಗೆ ಹಾಕಿ ಅದು.
your lordship, there's an MC case.
Where interim order is not extended, please take that.
Connected.
Give all the memos, other memos, please ಕೊಡಿ, yes.
Your lordship, there's an
If you want to
MC case.
give, call the cases, madam.
May I make one?
Lordship, please.
1 minute, sir.
There's an MC case, your
If you
lordship.
want to give the memo, give the memo. Yes.
My lord, petitioner has to go to abroad day after tomorrow, my lord.
Day after tomorrow, why have you fixed without taking the leave of the court? ನಿಮ್ ಪ್ರೋಗ್ರಾಮ್ ಹೆಂಗ್ ಫಿಕ್ಸ್ ಮಾಡ್ಕೊಂಡ್ರಿ?
No, my lord, as per, I mean, like, he has to go, or else, my lord, he can't able to continue his education, my lord.
Oh,
So there is-
ಆಯ್ತು ಕೊಡಿ. Yes.
My lord,
Tomorrow,
my lord, basically, my lord, as per previous memo, Thursday was scheduled, my lord. So
tomorrow you come give it, sir. ತಗೊಳ್ಳಿ ಮೇಡಮ್, ಆ ಸ್ಟೂಡೆಂಟ್ ಯಾವ್ದು ತಗೊಳ್ಳಿ, tomorrow.
tomorrow.
Pending ಕೊಡಿ, sir. Yes. How many extensions? Already I've granted everything. Just give it,
Your
yes.
lordship, one submission, your lordship. It was already posted for 12. This is a DV case. The respondents are really old, your lordship.
DV case or DA case?
Sorry, domestic violence case.
Domestic violence, all
Yes, your
right.
lordship, please, if you could post it maybe just before 12th.
No. Yes, Monday.
Requesting
Much
for
obliged.
It's a fresh matter or pending, madam?
Fresh matter, your lordship.
What's your, when is the next date there?
12th.
You are the husband?
Yes, your lordship.
No problem, Monday, yes.
My lord, these two matters are 2:30 minutes.
Why, sir?
My lord, my bank accounts have been freezed, my lords.
Tomorrow.
My lords, tomorrow, my lords.
ಅದೇ 2:30 ಕೇಳಿದ್ರೆ tomorrow ಕೊಡ್ತೀನಿ, day after tomorrow. Yes.
My lords, 2:30 only, my lords.
Tomorrow ಕೊಡಿ. FR ಅದ ತಗೊಂಡ್ಬಿಡಿ ವಾಪಸ್.
Hello, it is complied, my lords.
ಸುಮ್ನೆ ನೀವು ಆಫೀಸಿಗೆ ಬಂದ ತಕ್ಷಣ ಕ್ಲೈಂಟ್ ಇಲ್ಲಿ ಬಂದು ಒಂದು ಫೈಲ್ ಮಾಡಿ, don't do that.
I've complied with the office of
ಕಂಪ್ಲೇಂಟ್ ಇದ್ರೆ ಮಾತ್ರ.
My lords, tomorrow, my lords.
Tomorrow.
My bank accounts have been.
Your bank accounts won't be defrozen tomorrow, no worries, let it come.
One matter we had moved, my lords, your lordships, that's a Foxco case by the wife against the husband. By the time it came before my lords, your lordships were inclined to grant an interim stay. Charge sheet was filed, I brought it.
Things that came out were that in an increasingly digital world, a lot of the basic concepts, like, what is money? In today's times, none of us see actually physical money. Nowadays, even for a tip, the guy is showing you a QR code and you can decide how much tip to give. So some of these things are changing. The financial sector is changing and has to start understanding what the digital world means. It also means the policy and regulatory framework has to keep racing against time to catch up with it. Because partly regulators and government allows